So, welcome everyone to our next episode of Garris Horn Insights. I'm Ray Sneichel, and today we have partner David Ross with us to discuss what I think is certainly is a key topic for any business environment, certainly for counsel, but any business environment. So whether it's in-house counsel or the operational together for business, and that's attorney-client privilege and how that kind of works in the context of in real life, in business, when you're running a kind of a corporate setting, what works and what doesn't. How do you preserve it? How do you not? What is privilege and what is not? Welcome, David. Thank you for being on here.
Thanks, Ray. Thanks for having me. I appreciate it.
Great. All right. So let me cover some real quick disclaimers. I know, David, we want to be clear about some of these things. If you don't mind, I'll take the liberty to hit some of those as I see you want to talk about. So we're, first of all, anything we provide here that's often or always the case with Garris Horn Insights, it's not legal advice. Obviously, everything is different depending on your shop, what you're saying, certain contexts. So we don't want people to believe that what we have here is locked in legal advice. It's guidance that ultimately maybe could lead to legal advice if you get the right counsel. Additionally, what we talk about here is going to be some general standards. I mean, state to state things are different, but these are general standards for attorney-client privilege. It's not necessarily your state that you're in or even the state I'm in. It's just general concept of attorney-client privilege. So keep that in mind. And I think just for ease and for comfort, I think we often talk about corporate or corporations in certain contexts, but that really means kind of like the entity, which is a clumsy word. So we're talking LLCs or LLPs or anything like that, right, as well. So the entity. But if we reference then, David, I suppose when we reference things like corporate or corporation, we're basically applying it to the entity. So it can be applied globally, I suppose. So
yes.
That pretty much? Okay, well, I just want to make sure we cover that. And so let me ask you, David, tell me about attorney-client privilege. What do I know? What should we know?
Okay. Attorney-client privilege is something that attaches to communications between an attorney and the client. It belongs to the client, not to the attorney. The client can waive attorney-client privilege. The challenge is that waiver can occur inadvertently. And that is one of the reasons we need to be extremely clear on who our client is, when attorney-client privilege attaches and when it doesn't. And in our context of corporation, it's important to know exactly who the client is. It's important to know who is speaking for the client, who is properly present when there's a communication between the attorney and someone who works for or is associated in some way with the corporation in order to preserve that type of privilege. Where you need to start with a corporate client is understanding exactly who your client is. Now, a couple additional disclaimers here. One of them is that I know this audience consists partly of in-house counsel, partly of people who are not attorneys. I'm going to speak a little bit in the language of an attorney, partly because there are things I want to impart to the in-house counsel, and partly because the other people, the lay people, need to understand the perspective, the context in which some of this stuff is operating. So understanding who the client is important on a couple of different levels, and one of them is purely an ethical level of avoiding conflicts of interest. So if, for example, the vice president of the corporation says something to the counsel for the corporation, and that something is not really in the best interests of the best interests of the corporation as a whole, then that means the vice president and the client are really in conflict. So it's important to avoid conflicts of interest. It's also important generally for attorney-client privilege purposes, and that consists of both an ethical end and just what we call a common law end, how the courts tend to rule. So one thing I should say is that when I'm going to quote rules of professional conduct, I'm referring to model rules from the American Bar Association. So it would be, for example, ABA RPC 1.7. I'm doing this because standards differ from state to state, but they generally look similar. And some states, many states, will adopt the RPC's essentially word. So we're talking when it comes to attorney-client privilege, we have a confidentiality obligation under 1.6. We have a common law issue, meaning are the courts going to decide that a privilege actually exists? Are we going to allow this secret to continue to exist if there is some sort of dispute? So that sounds easy enough. If I'm talking to Joe and Joe is my client, then the discussion between the two of us is generally privileged if it is a conversation that occurs for the purposes of giving legal advice. It gets a little more confusing when other people are present. If Joe's friend is present and Joe has nothing to do with the legal advice, nothing to do with anything else, then it looks like Joe has waived that privilege. So the question is, who can be present? Who should not be present for different discussions? That is key to preserving attorney-client privilege. So in sum, the privilege belongs to the client. The privilege is waivable only by the client, but waiver does not have to be conscious or intentional.
So it really could be accidental, and if we're not careful, putting it
It
another
can
way.
be accidental if we're not careful. So let's talk about an organization as a client. Funny thing about a business entity such as a corporation or a limited liability company, et cetera, is it's treated like a quote unquote person under the law. It has its own identity, separate and apart from the people who make it up. And usually when it comes to a corporation, it's that fictitious person, ABC Corp, that is the client. It's not the management. It's not the employees. It's usually not the shareholders or principals. So model rule of professional conduct A says, quote, a lawyer employed by or retained by an organization represents the organization acting through its duly authorized constituents. So lawyer employed by could be an in-house counsel, retained by outside counsel. The organization represents the organization acting through the duly authorized constituents. So the people that are communicating are not the clients. The people who are communicating, if things are done correctly, are the representatives of the client. Now, having said that, by agreement, the lawyers can enter into attorney-client relationships with subcomponents or components of the organization itself. For example, it could be with the board of directors. The relationship could be even with a committee of the board of directors. So let's get to, if I may, the issue of sort of a conflict existing. What happens if the people who are supposed to be acting on behalf of the corporation are doing something that they're not supposed to? And when I say doing something not supposed to, I don't mean that they're failing to use their best judgment. I mean that they are engaged in actual wrongdoing. Something that could be a violation of the law, or it could be a violation of a legal obligation to the corporation. So it's a very rare circumstance, very rare, under RPC 1.13b, where the lawyer is supposed to essentially blow the whistle. A lot of things have to happen before the organization's lawyer is supposed to go further. Okay. So the lawyer has to know, not suspect, not have a feeling, but know that someone such as an officer, an employee, another person associated with the organization is either intends to be engaged in wrongdoing, or refuses to act in a way that ends up harming or is likely to cause substantial injury to the organization, and it violates a legal obligation to the organization, or it is a violation of the law that reasonably might be imputed to the organization. That's a lot of stuff that this person has to know. It doesn't necessarily mean, and it doesn't mean, that the lawyer blows the whistle to the public at that point. If something is going to happen like that, and a violation is likely, not possibly, but likely to result in substantial injury, not just some injury, but substantial injury to the organization, the attorney is supposed to go up the internal food chain, find higher authority, perhaps go all the way up to the highest authority. Now, in a really rare circumstance, the person up top refuses or fails to fix the problem. Then the lawyer isn't required to, but may reveal information if that lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization. But even that revelation is supposed to be extremely narrow. It's only to the extent that the lawyer reasonably believes necessary to prevent substantial injury to the organization. This is the pull the fire alarm type of situation that hopefully nobody who's watching or listening to this, if they're corporate counsel, ever have to face, and they most likely won't.
Well, let me put that a little bit in context. So basically, now we're talking about an in-house counsel in this instance.
It can be an in-house counsel. It can be
And
an
the
outside attorney.
Very good. Okay, very good. So, because it's very interesting. So, there's an obligation for them to escalate if one of those duly authorized individuals who are in place to run the company. And I'm going to say it's usually not going to be a supervisor, but it could be, but I mean, not necessarily. We're talking really the sticky issues are going to be when it's your CFO, your COO, your CEO, of course, maybe a board member, I suppose. But in some fashion becomes an issue. They have an obligation to escalate. Does that make sense? Did I get that right?
Yes. And that obligation, the obligation is an internal one. The break the glass in case of emergency isn't stated as an obligation. It's stated as something that the attorney may do, meaning, but tread carefully. So this is important, I think, particularly with the types of clients that this firm tends to represent, type of work that our firm tends to do with regard to regulatory compliance and investigations. There is an exception to the reporting obligation where we're dealing with an internal investigation or we're dealing with defense related to an alleged violation of the law within the company. If you hire someone to say, look, I want to see if there was wrongdoing within here, or we want you, attorney, to defend the organization or the person who did this thing or allegedly did this thing against a claim related to this. At that point, there is no duty to reveal. And in fact, if you're an attorney, you'd better not reveal it because you do have that obligation of confidentiality under the ethical rules. So here is something that's really crucial is that fiduciaries and principals, I'm talking about directors, officers, employees, shareholders, etc., need to understand where the boundaries are. I don't expect anybody to have a chart up in their office, but it's the really responsibility of the counsel to allow those people to know where those lines are, particularly if the organization's interests are adverse to those people's interests. So, and that is Rule 1.13F, that if the attorney reasonably knows or reasonably should know that there is a conflict, the attorney has to make it clear to these people, I'm not your attorney. I'm the attorney for the organization. I'm not you. It's not like you can just send me an email, tell me you're going to do something bad, and then it's protected. That's not how it works. There are two issues there. One of them is knowing who the client is. And even if there was attorney-client privilege existing in communications between person X and attorney Y, it wouldn't necessarily exist with regard to furtherance of criminal activity, fraud, et cetera. Anyway, so that has to be revealed. That has to be understood.
I think it's interesting you say that because we have to remind ourselves that the client, remember, you said it from the beginning and you've been saying it through, and I'm just reiterating, the client is the entity, it's the corporation, right?
Yes.
And having been general counsel, I've been general counsel a few decades myself. It's hard to those who are not attorneys or those in the operations don't always know that. So you'll have someone in sales come to me and say, "I have an issue. I want you to see. Can you help take care of it?" It's like my obligations to the company. So I don't know if we're going to be adverse. You might not want to tell me. Right at the end of the day, it's kind of like I have to really stand there on behalf of the company. I am not your lawyer, and that's something I think that sometimes gets lost. Certainly, I think the attorneys, in-house attorneys, would know that, but I think sometimes that gets lost in the process. Is I'm not the employee's attorney. I am the attorney for the entity itself, the living organism, which is the corporation, and then through its agents and its fiduciaries. I get that. Those are the ones who do the mechanical people, who really move the company around as the body. But the company itself is its own thing. So I am the company's attorney is really the point, is what I gather.
Right. And in some cases, which I'll get into in a little bit, the attorney can represent both the corporation and an employee and an officer and the director. But that's a special circumstance. That's not the default. So the question is, a question is, well, what can we say to what employees, if we're counsel, to ensure that we're speaking with the client. I'm giving air quotes for anybody who's just listening and not watching, so that we don't end up waiving attorney-client privilege. Because sometimes it's an employee's presence, as strange as that might sound, it's an employee's presence that might break the attorney-client privilege of the organization. So the question is, with whom can the attorney speak? And the secondary question is, what can be said or what can be heard from various people? So the old federal standard, which is now the standard that's recognized in a very small minority of states, I mean, it's really just a handful, is called the control group standard. And in a way, it's very simple. The question of whether privilege attaches depends on the employee's position and the ability to take action on the corporation's behalf per advice of counsel. So usually this is something that must come from or relate to senior management. And that is, for the most part, passé. When things changed on the federal end, and subsequently things largely changed on the state end, most of the states, the change came from a U.S. Supreme Court decision, Upjohn Company versus U.S. That's a 1981 case. And that is the subject matter standard. So that's a federal standard adopted by almost all of the states. And this says, well, you can talk to an employee and still protect attorney-client privilege, but it depends on the subject matter, depends on what you're doing. Okay, so there are certain elements that have to be met, and there are certain hoops that need to be jumped through. Okay, so the elements, the communication has to be made for the purpose of giving or receiving legal advice. An employee who is not someone from the traditional control group who's communicating with the attorney needs to be doing so at the direction of the supervisor. And that direction has to be provided by the supervisor with the intent that it's going to enable the company to obtain legal advice. And the subject matter must be within the scope of the employee's duties. And the communication is not to be disseminated beyond the individuals who within the corporate structure need to know. So this is important. So if there was a slip and fall, right, then perhaps the guard that was on duty is someone with whom you can have an attorney-client communication with if you're in-house, or if you're the supervisor or person whom you can direct to speak with counsel for that purpose. Now, in lawyer speak, this is not a self-executing privilege. I mean, it doesn't just happen. It doesn't just occur. There are things that, even if the elements are met, the attorney must do. The attorney must give the Upjohn warning and say to the person, security guard, I represent the company. I don't represent you. And then the attorney needs to confirm that the employee has information that's not generally available elsewhere. So if the president was around for all of this and has that information, has firsthand information, we really shouldn't be talking to the security guard. And the other thing that needs to be confirmed is that the lawyer needs this information in order to advise the corporate client, right? And then, going back to something I just said before, the employee needs to be told not to disclose the subject matter of the communication, except to other employees with a need to know. Okay, so we're going to keep this communication very narrow. It doesn't go beyond the scope of what needs to be communicated between the attorney and that lower level employee. And this need to know standard goes beyond just what the employee says, but also what the employee is told. So, for example, if the attorney is speaking with a security guard who was present for the slip and fall, the attorney should not be talking to the security guard with regard to needed updates to the handbook to prevent this type of injury occurring in the future. That could be the type of thing that goes beyond the scope and is not privileged necessarily, or maybe even breaks privilege. It's important if everyone's in the conversation. So normally that wouldn't happen. Let's just talk about something more realistic. Let's say that the security guard is in the meeting and sitting there with the bigwigs and the attorney, and they're discussing what happened. Well, the danger is we talk about, you know what, we really need to change the handbook. We really should do this, we should do that, we should do the other thing. What needs to happen is security guard needs to be thanked, asked to leave the room before the rest of that communication occurs. That person shouldn't be around for that portion of it.
And in that example, the part of the communication that's at risk is the updating of the handbook, right? So which could be an issue.
Right.
Now, would it be, but the part about the facts of the slip and fall, assuming again they had the firsthand account, nobody else did, that part would remain attorney-client privilege, you believe? Or and then even then, if we don't know, it'd be dangerous. It's a slippery
It
slope.
could be it could be dangerous. Here's what I would think. I think if the person who's present is a decision maker, it shouldn't break privilege. If you have somebody else, and this is an open question in my mind, okay? But I would say that if you have another person who does not need to be there, who maybe is going to talk about the structure of the sidewalk or something else, that person shouldn't be in the room while you're talking to the security guard.
In your example, I can see how that issue could manifest, right? Because you're right. When we're talking about a slip and fall, I can see it. So it's going to be the attorney, the president in the room. It's going to be, sake of discussion, HR, right? It's going to be, of course, the witness, in this case, the security guard. And it's also maybe the guy from facilities or maintenance. And so the conversation could easily evolve. And these are all critical conversations, by the way. In other words, an admission of updating the guidelines or discussing that, oh yeah, that sidewalk is sloped anyway, is an admission of maybe possible liability. So you think like the guy in maintenance or facilities is like, yeah, we knew we had a problem with that. You know what? We don't want that in this conversation because that wasn't the scope of the intent meeting. I'm sure there's defenses and so on and so forth, but the whole point is this is where no pun intended, the slippery slope of the issue, right? It's
Sure.
who's in the room. It really needs someone who needs to know, and only in the scope of why we're having the conversation. It sounds like that's what it seems.
Right. Now, I should say that to the extent we're saying, hey, we need to fix this, everything else, you could have what's called a subsequent remedial measure, and maybe it can't be used against you. But the conversation itself is something that might not end up being protected, and the
That's
admission that comes with it
correct.
that
That's what
you
I'm
just
saying. It's,
mentioned.
it's like, we don't want to dissuade anyone from making changes and so on and so forth. There's certain things, but there are certain legal protocols in all of these. And that's why I said we might have defenses, but did you really need to even put yourself in a defense if that person just wasn't in the room and have a separate conversation and again with counsel on that particular issue? So I think you have to be laser focused on the topic, the agenda, if you will, of what's being discussed with counsel and why somebody's there in that regard. And also limit who's in the room. I think this is not casual by any means. So I think it really needs to, who's in the room needs to be thought about. And I've had to deal with that before. At the end of the day, it's just easier to keep it tight. And I think the phrase is need to know.
Right. So there's another issue, and I won't go deeply into it, but sometimes the communication does not have to be from the attorney directly to the recipient in order for attorney-client privilege to continue applying. For example, president communicates with security guard and says, security guard, this is what corporate counsel says we need to do from this point forward. Or corporate counsel asked me to ask you this question and communicate it over. So there are ways to address that issue. I actually had that issue come up in a deposition this past week where I was claiming the privilege because the president communicated something from the attorney to someone who was a little lower on the food chain. It related to the representation, and the other side was objecting like crazy, saying this was not a communication. This was a president who's not a lawyer, and it doesn't matter. The president is acting really as a go-between, acting as an agent there. That's why. Here's what I should say, by the way, when it comes to just a little practical advice, when it comes to internal investigations of wrongdoing, something is going through, if you want to protect it, the best thing to do is to make it clear you're having these communications for purposes of ultimately communicating with counsel. So say attorney-client privilege, label it that, say, look, at the direction of counsel, I'm asking you X, Y, and Z. I'm trying to get this information to communicate to counsel. You do that type of thing to make it clear if somebody, God forbid, a judge later on is looking at this stuff in chambers to see if privilege attaches, you need to take these steps.
And I would say, again, correct me if I'm wrong, so I want to explore it a little bit with you, is in that context, and I know it should sound obvious, but I want to be clear, counsel really did want the information or expect the information to be relayed. Or in the sense of investigation, counsel is aware of the investigation or may have actually initiated the investigation under their umbrella. Does that make sense?
Yes, I'm not suggesting anybody should make that up to create some magic shield. I'm saying that if this is what's being done, then the necessary steps need to be taken
Agreed.
to ensure that that privilege is being preserved.
And to be clear, I don't think you were being oblique about it. I just wanted to make very clear to others that just the president saying, I'm going to start an investigation. Hey, we're just going to say corporate counsel said this and I'll talk to him later. No, corporate counsel needs to know first before, and then have the strategy on communicating as a result. And that it goes back to slippery slope, and in an operational business environment that could happen,
Yeah.
but be careful because now we have questions as to where the privilege will attach.
Yes. So one thing I should also say is if you have corporate affiliates, there's an interesting issue is, well, let's say we just have a corporate family and things tend to be, a little dispersed, but we're all part of the same corporate family. Well, can company A's counsel communicate with employees of company B? Well, it depends. Partly it depends on what jurisdiction you're in, but usually most courts, from my understanding, will apply the attorney-client privilege to communications between a corporation's lawyers and the employees of wholly owned corporate affiliates. And maybe corporations that are related through common ownership or control, wholly owned subsidiaries, parents, maybe a 90% owner of an affiliated entity, those types of things. But you got to check your jurisdiction. You got to check your particular facts. You got to be careful when it comes to any of this. Now, we talked about something before, changing gears again, and this is sort of the last thing I just wanted to be sure to hit, is that, again, sometimes an organization's attorney, whether it's the in-house or whether it is outside counsel, will represent the entity on the one hand and directors, officers, employees, principals, or someone else on the other. Okay. And usually I would say it's probably not going to be plural when I say directors, officers, employees, principals. The larger it gets, the more unwieldy it gets. Under Rule 1.13G, this is permissible if RPC 1.7, dealing with conflicts of interest with current clients, is satisfied. Okay, so generally, it says 1.7A says that except as provided in subsection B, which is, okay, so that's the exception. A lawyer generally cannot represent a client if the representation involves conflicts of interest that are concurrent with one another. Okay, so either directly adverse or significant risk that the representation of one client will be materially limited by the responsibilities to another client or to another person. Okay, so the exception is in some circumstances, not all, but in some, there can be informed consent. Okay, informed consent in writing is enough in certain circumstances. Now, what happens if vice president says, well, these decisions are usually made by me, and as luck would have it, I'm the person who seeks the representation. I approve. No, it doesn't work that way. The consent has to be given by either an appropriate official other than the one to be represented, or by the shareholders. So it's another degree of protection. So you might see often. I used to see this particularly in cases. I was at a firm that did a lot of employment law. We'd have these dual. They'd be separate representations. You'd have the company and you'd have the supervisor who allegedly committed sexual harassment. And they're represented by separate counsel. They're all working together, but generally at the end of the day, there's a possibility that the company could say, look, we did everything we could. How could we know what this guy was going to do? There is always the possibility that the interests end up conflicting.
I agree with you. I've seen that in, like I said, my experience as well, because you don't know when you go through the process and unearth the facts and put it in the proper perspective. And I'm saying from a legal perspective, you might unearth the fact that what looked like there was going to be no conflict slightly does, and now it's kind of clumsy at a minimum, and it's a legal problem in maximum. And so I've seen that, in our environment, particularly in my case, I was a mortgage company. So we have to be very careful about that. I don't say you can't do it because, like you said, the rules permit it. But I think we have to be very thoughtful about that as to who the client is, just to keep our nose clean. Because at the end of the day, it's the company we represent, and I don't want to compromise them. So it could be challenging sometimes, but yeah, I have had to navigate that before.
Yeah, and the way it often happens is that the two parties will act very much in concert with one another. They're allies. Maybe they even have a joint defense agreement that wherein certain communications would be permissible between them all in front of each other, in front of attorneys, without waiving attorney-client privilege. But at the end of the day, they can still say what they want to their own respective attorneys. That keeps them separate.
Well, thanks, David. What I'm hearing basically is, first of all, don't take attorney-client privilege to be so easy. It's some discipline you have to apply to make sure it's done correctly and it's well preserved. I think the way to do that is to be very thoughtful, very judicious in the topics. If you believe there's issues that require attorney-client privilege, if you think there are things that require attorney-client privilege, that you get very focused on what you're going to say, with whom you're going to say it, and who's going to be in the room when it's said. And if there's any doubt, then don't bring them in. If you're not an attorney, and especially and you have any doubt, check with your lawyer, is what I'm hearing, and they can help you navigate that. But don't presume that having HR in the room on a particular issue that might relate to HR will automatically go under attorney-client privilege. It might not, depending on the purpose of the conversations. Well, I want to thank you for all the information you provided. It's extremely important, and I know it's a field that one thing is always moving. We got court cases all the time in different jurisdictions regarding attorney-client privilege. They get challenged. So any last thoughts or advice you can give us on this topic, David?
The only thing I would do is reiterate what you just said. I mean, and I'll say it in a slightly different way, in that don't approach this casually. These issues can be minefields. So I would err on the side of safety. If there's any doubt, take a step back before you plunge in.
Well, thank you, David. And thank you, everyone, for listening to Garris Horn Insights. And we hope to see you at our next episode. Thank you. Thank you, David.